2022 recap session 6. We are going to revise current affairs for prelims with respect to important bills passed by Parliament in the year 2022 for the prelims 2023. This particular session deals with 7 important bills, and few bills were newly introduced or legislated, and few are amendments which were done to already existing bills. The first one, Indian Antarctic Bill 2022. It is one of the important bills which we need to read because this bill is necessitating to give the effect to the treaty on Antarctic. So this is one of the important treaties which India is member to. And another important international treaty is that Convention on Conservation of Antarctic Marine Living Resources and Protocol on Environment Protection to Antarctic Treaty. All these three constitutes the Antarctic treaties collectively. And to set the things right on part of India, so we need Indian Antarctic Bill. And this particular bill also seeks to protect Antarctic environment and regulate activities in the region from the Indian side. According to this bill, the area of Antarctica includes the entire continent of Antarctica and all islands of Antarctica and the airspace south of 60 degrees south latitude. Remember, here Antarctica doesn't mean our bases alone. So Antarctica is the entire continent. So in the prelims, possibly they may say that the Indian bill is applicable only to the bases in India, in Antarctica, but that is with respect to India, but it is comprising the entire continent of Antarctica, right? And this particular bill has some of the key features. According to the international obligation, we are going to set up a committee on Antarctic governance and environmental protection. So it will be headed by Secretary of Ministry of Earth Sciences. Remember, it is going to be Earth Sciences. And there will be 10 members. And these members will be nominated by the Union government from different ministries, defense background, research institutions and organizations. And the function of the particular committee will be primarily granting permits for various activities in Antarctica to move into the research stations and so on, and implementing and ensuring the compliance of the Antarctic treaties and providing relevant information by the parties to the treaty, and negotiating fees and charges with other parties in the activities in Antarctica. So in case if they want to travel to the part where India is, so how the fees and charges are going to be, everything will be negotiated by this committee. And the second important thing is why we need a permit. We need to have the permit because the resources are very fragile, and it's part of our resources there in the bases and so on. Research stations are there, and it's a collective effort to put Antarctica under a protective thing. So you need to have a permit from an Indian expedition to enter into or remain in Antarctica, and a person to enter or remain in Indian station. So it is both entering or remain in Antarctica as well as in Indian station, a vessel or aircraft registered in India to enter in Antarctica. And then you have a person or vessel to drill, dredge or excavate any mineral resource. You need to have it. And any activity that may harm the native species of Antarctica, and waste disposal. So all these needs permit. In case if someone is not having permit and enter into Antarctica, and they may have a minimum imprisonment of 7 years and a minimum penalty of 10 lakhs. And in case if they are going to involve in certain prohibited activities like nuclear explosion or radioactive waste disposal, non-sterile soil extraction, or discharge of garbage, plastic and other things into sea, they may have, for the nuclear explosion, other stuff, they may have a penalty extending up to 50 crores and imprisonment of up to 20 years. So these are some of the important provisions of this particular bill, and try to have an idea on Indian base in Antarctica. Right? Then the second important bill which was introduced and passed in the Parliament was Criminal Procedure Identification Bill, which was also ending in some controversies in certain times. And this particular bill was replacing Identification of Prisoners Act, which is a century-old act in 1920. And this was initiated by Justice V.S. Malimath Expert Committee on Reforms of Criminal Justice System, which was set up in 2003. And this particular, that is 2003, it recommended an act to replace this particular act of 1920, or at least amend it. So basically, the Criminal Procedure Identification Bill provides three things. One, what type of data can be collected and from whom you can collect and who will collect it. Okay, so these three aspects it deals with. So the first one, what type of data can be collected? The 1920 Act provides only for fingerprints, footprint, impressions, and photographs from the convicts or accused. Whereas now we have included in the Criminal Procedure Identification Bill biological samples and their analysis, behavioral attributes like signature, handwriting, etc. And under CRPC sections, it can include some biological samples like blood, semen, hair samples, swabs, and other analysis for DNA profiling. So remember, the DNA profiling bill is still under consideration, and it is being reviewed, and it is not yet passed. But Criminal Procedure Identification Bill has a provision for DNA profiling. Clear? So this is one issue what we have. But anyway, data can be permitted in these aspects. So from whom we can collect? So we can collect informations in two methods. One can be where forcibly can be taken, whereas the other may require, that means you will have some concurrence after that we try to do. So any convict or arrested person for any offense, okay, for any offense, have to share personal data with the authorities under this particular thing. So the person can be either convict or just arrested for any offense. Remember that it is any offense. However, biological samples can be forcibly taken only from offenses related to women or child, or any offense which carries minimum of 7 years imprisonment. Okay, so any offense which is related to 7 years imprisonment or against women or child, that person can be compelled to provide the data in this particular aspect. And then the next important thing is that the persons who may require or direct to collect data, that is, who is authorized to do it. The authorization is given by the officer in charge of a police station or of rank head constable or above. And this particular data can be collected with the head warden of that particular prison. So it has to be done. And apart from that, we need to have a metropolitan magistrate or judicial magistrate of first class, and that particular authorization is important. Okay, so these are some of the important provisions what we have in this particular Criminal Procedure Identification Bill 2022. And who is going to have certain property of this? Say, for example, you can see National Crime Records Bureau is a central agency to maintain the records under this particular act, okay, or a bill which is passed. And it will share the data with all law enforcement agencies. So it will be the repository and it will share to other agencies. The states and UTs can also notify agencies which can collect and preserve and share data. Remember, they can collect, preserve, and share data in respective jurisdictions, because there are states and UTs which can have their own law and order issues, which they can also collect under this Criminal Procedure Identification Bill. And It will be retained in the digital form for 75 years. Remember, it will be for a very long time, 75 years. And the records will be destroyed in case the persons are acquitted after all appeals or released without any trial. And in case a court or magistrate may direct the retention, then it can be retained, but it should be in writing. Okay. So these are some of the major aspects with respect to prelims. So they can ask you about which is a central authority to manage it, the data, and so on, how many years it can have, and so on. So for detailed provisions of this bill and analysis, you can visit our Instagram page where we have the issue number 58. The link has been provided in the description. You can check it out for the detailed analysis. Then the new bill which we have is National Anti-Doping Bill 2021. So this bill was introduced in 2021 and it was passed in 2022. And this bill was an important bill which we are necessitated to have it because previously we don't have a law. So only by rules we started providing the anti-doping regulations in India, which can be easily manipulated and cases will be largely lingering around the authorities. So what happened? We want to prohibit athletes or athlete support personnel, that is coach and others, and other persons from engaging in doping in sport. Doping is taking some medicine for to have more enthu in this particular or catalyst to perform better. So this particular bill provides for constituting an agency called National Anti-Doping Agency or authority agency as an authority which has a statutory body. Okay, so as a statutory body. So before that also we had anti-doping agency, but it was a society, okay, not a statutory body. Now the law will provide its legal backing, and this law will also provide the thing that India will have its own anti-doping law, right? So the society is now converted into a statutory body. And since 2009, the NADA is there, but now we are in 2021, we had a bill for that statutory backing. And NADA was operating under World Anti-Doping Agency, WADA. In 2019, we had highest number of positive samples, followed by US and Russia. So all these compelled and necessitated a new law which can improve the image of India internationally. So some of the key features is that under this, we have NADA. After NADA, we have National Board for Anti-Doping in Sports. This will be the board which advises government with regarding the anti-doping regulations, compliances, and see. And this will oversee the activities of NADA. So the National Board for Anti-Doping in Sports will be the apex body kind, and below which you have NADA, the agency operating. And the board will constitute two important bodies. One is National Anti-Doping Disciplinary Panel, and the board also has National Anti-Doping Appeal Panel. Okay, so appeal panel. So this appeal panel will be headed by a retired judge. Okay, so this is how the two bodies are there under this board. So in case any consequence of violations, these disciplinary panel will take up. And in case you want to have some appeal, you can go for the appeal panel. Okay, so this is how the anti-doping bill is presented. So the important issues in this aspect is that there are two issues. One is the Director General of NADA doesn't have any qualifications specified in the bill, and only the rules will provide. And the central government may remove the Director General from the office on grounds of misbehavior, which is okay, or incapacity, but such other ground. So what is that such other ground is a major hurdle. Okay. And similarly, under the bill, the board has powers to remove the members of the disciplinary panel and the appeal panel on grounds which will be specified by regulations and are not specified in the bill. So that is another problem, what it is. So there, the devil lies in the details, and there is no requirement to give any opportunity of being heard. So this is another problem. What it happens. Okay. So WADA, which operates since 1999, is a recognized body under UNESCO International Convention Against Doping in Sports since 2005. So this is an additional fact which you need to remember in this particular case. So the next important bill is Delhi Municipal Corporation Amendment Bill 2022. Even recently, it has been a boiling situation in Delhi with respect to these elections. Actually, the Delhi Municipal Corporation Act was passed in 1957, and this particular municipal corporation is as old as 1860s. And this municipal corporation act was amended in 2011, where this corporation was trifurcated. Okay, so that is, Delhi was divided into 3 different corporations, and 3 different mayors were there. But this 2011 amendment gave the superior hand to Delhi government on deciding these. But the recent amendment bill, which was passed in the parliament, and subsequent elections were conducted, and that bill removed this trifurcation, and again it unified the corporation into a single body. And all these functions, like fixing the number of seats of councillors and number of seats reserved for the members of SCs, division of zones, delimitation of wards, salaries and allowances, and leave of absence of the commissioner, sanctioning the consolidations of loans by a corporation, sanctioning the suits of for compensation, everything will be decided by the union government than the Delhi government, which is now the power transfer. So now the Delhi government doesn't have any say over these in the corporation, whereas a union government will have all the say. So this is the difference between 2011 and 2022 amendment. And now the new bill, the total number of councillors in the corporation should not be more than 250. Previously, it was around 270, so they have reduced the numbers. And the bill also provides the central government power to appoint a special officer, which is also present in the previous thing, whereas there will be a commissioner for all other purposes. So you have 2 officials related to this from the central government. And apart from 250 councillors, there will be 1/5 approximately members of the Legislative Assembly, that is MLAs, okay, basically MLAs. So 1/5 of the MLAs will be appointed in a rotation basis. So they may be comprising that 1/5 may be from different parts of Delhi constituencies or within a part. So, but they will be kept on rotation, right? And then the MPs representing Delhi will be nominated as members in the corporation. So they will be also important participant. Apart from these 2, MLAs and MPs who represent through nomination, there will be 10 members who were nominated as aldermen by the Lieutenant Governor. This was a dispute because whether they can vote or not. Now Supreme Court has clearly instructed that they cannot vote. Okay, they don't have voting rights. So nominated members doesn't have voting rights. So this is how it is. So the mayor will be elected only by the councillors who are elected by the people, right? So this is how it happens. So the next important bill is the Weapons of Mass Destruction and their Delivery Systems, Prohibitions of Unlawful Activities, Amendment Bill 2022. Actually, we have an act which is passed in 2005, where the unlawful activities with related to weapons of mass destruction and their delivery is being prohibited. That is manufacturing. So in 2005 Act, manufacturing, transport, or transfer is prohibited or made as unlawful. Whereas now the bill also includes financing. Okay, so bill also includes financing. This is one. So if a person is found to finance such activities, the government may freeze, seize, or attach those funds with them. Okay, so this is one. Another thing is it also prohibits making some finances related. Okay, so It's basically restricting finance apart from manufacturing, transport, and transfer. So, and this weapons of mass destruction are biological, chemical, and nuclear weapons, and it can be of any sort. Okay. For the detailed provisions, refer issue number 64 in our Instagram page, where the link is also provided in the description. Then another important bill which you need to remember with respect to environment, the Wildlife Protection Amendment Bill 2021. So this bill is introduced so that the Wildlife Protection Act 1972 will be amended to go with the provisions of CITES, right? Convention on International Trade in Endangered Species of Wildlife, that is flora and fauna. So under the CITES, we have different categories of appendixes, which are categorized according to the specimen which have protection. So same, similar kind of categories we are also upbringing in the Wildlife Protection Act, and that's the reason why we want to have this bill. So under this bill, we are rationalizing the schedules. Presently, we have 6 schedules. So one is for plant, 4 is for animals, and 1 is for vermin. So vermin means, you know, the animal which carries a disease or destroy food, which can be shot, okay, so hunted by the farmers or any other person. So now we are reducing it to 4. Okay, so now in the bill, we have 2 for protected animals. The schedule for vermin has been reduced, and new schedule for specific species listed under CITES have been included. Okay, so that is one important thing which we have in this regard. So totally we have 4 schedules. So remember that. So this is one of the important things. So when the bill is introduced and passed, and when the government order comes in, we can see how many schedules are there, which part the schedule is going to be the greater level of protection and the lesser level of protection, and how the classification happens. So it is important. Then under CITES, we are obligated to create a management authority and a scientific authority which will have specific functions. Management authority will grant export or import permits for trading in specimens, and scientific authority will advise the government with relate to impact of survival of specimens traded. So here the management authority will have certain powers, like providing some identification mark for a specimen. Okay, if a particular specimen which is being traded, there may be some identification mark. The bill prohibits any person to modify or remove this particular identification mark, and every person possessing live specimen of the scheduled animals must obtain the registration certificate from the management authority. Otherwise, there will be penalty, minimum of 25,000 for a specific species, or up to 1 lakh rupees for general violations under this particular law. So this is one of the important amendment what we have made with respect to the creation of management authority and scientific authority. Apart from that, as far as invasive alien species, the bill empowers the central government to regulate or prohibit the import, trade, possession, proliferation of invasive species, because forest comes under the concurrent. Some states have some law, so now the union government also has some law. And the bill also empowers the union government to have conservation reserves. Thereby, the conservation reserve can be created not only by the state governments, but also by the central government. So why this conservation reserve? It was for protecting the flora and fauna in the adjacent areas near the parks and the sanctuaries. And the bill also provides for a provision to voluntarily surrender any captive animals, okay, to the chief wildlife warden in the state, and no compensation will be provided to that particular person, and the surrendered specimen will be property of the state. So these are some of the important provisions what we have with respect to Wildlife Protection Amendment Bill 2021 passed in 2022. Then comes the Energy Conservation Amendment Bill 2022, and this particular bill amended the Electricity Conservation Act. In this, they are introducing an important provision regarding the carbon credit trading scheme. And also it all provides the central government to designate consumers with certain proportion of energy to be used from non-fossil fuels, as well as applicable of this particular provision in the energy conservation code for buildings where office, residential buildings which are having 100 kilowatt or above, or energy consumption standards can be specified for vehicles or ships. All these powers are given to central government under this particular amendment. And apart from that, you can see the carbon trading or carbon credit trading aims to reduce carbon emission. And this particular issue is that whether the Ministry of Power is going to be the appropriate ministry or some other ministry is going to involve in this particular issue. And apart from that, who is going to be the market regulator for this particular carbon credit trading? That is also there in this particular act, which is not mentioned. And similarly, the activity which is eligible under renewable energy savings or carbon credit certificates, the bill does not specify whether these certificates are interchangeable, because say energy saving is different, eligible for energy renewable energy is different, so carbon credit certificate is different. So whether it is interchangeable is a question. And the meeting of standards and obligations, all these are some of the issues highlighted in the bill when it was discussed. Okay, so for the detailed analysis, you can also refer issue number 123 in our Instagram page, so that you can get the details. So these are some of the important bills passed in 2022, which is important for the prelims in 2023. So for further sessions, stay tuned with us. Thank you.